The Supreme Court issued unanimous 9-0 decision in Case v. Montana that changed when police can enter your home without a warrant. By the end of this video, you will understand what this Fourth Amendment ruling could mean. If you want the source links, ask in the comments and I will share them. So, let's get into it. Justice Elena Kagan, writing for all 9 justices, established police need only objectively reasonable basis for believing that occupant is seriously injured or imminently threatened to lawfully enter without warrant under emergency aid exception. Court rejected full probable cause, but also rejected lowering standard to reasonable suspicion, creating middle ground gun owners must understand, because wellness checks and concerned neighbor reports increasingly justify warrantless entries, leading to gun discoveries and red flag petitions. Subscribe, because emergency aid exception is expanding after Case 5 Montana, and knowing what police can and cannot do when they show up claiming someone needs help is critical for every gun owner. Supreme Court took up Case v. Montana to resolve circuit split over what standard police must meet to invoke emergency aid exception to Fourth Amendment's warrant requirement. In unanimous opinion, court established police need objectively reasonable basis to believe someone inside seriously injured or imminently threatened, lower than probable cause, but higher than reasonable suspicion. For gun owners, this matters because police entering homes under emergency aid exception don't need search warrants, but can observe and report firearms they see, potentially triggering red flag petitions. Let me break down what happened in Case 5 Montana, what objectively reasonable basis standard means, why court unanimously chose this middle ground, how this affects gun owners during wellness checks, and what you should do when police claim emergency to enter without warrant. Number 1. What happened in Case 5 Montana incident? In Montana, neighbors called 911, reporting loud crashing sounds and yelling from residents, expressed concern someone might be hurt. Police arrived and approached home. Police actions. Officers knocked repeatedly. No answer. Heard sounds inside described as moaning or distressed sounds. Announced presence as police responding to emergency. Still no answer. Tried door, unlocked. Based on sounds, unanswered knocks, neighbor report, officers entered without warrant under emergency aid exception. What police found upon entering. Found resident Case lying on floor, conscious but injured from apparent fall. Officers also observed firearms in plain view throughout home, rifles leaning against walls, handguns on tables. Called medical services. After medical evaluation, determined Case intoxicated but not seriously injured. Officers filed report noting firearms observed, expressing concerns about Case's ability to safely possess firearms given intoxication and injuries. Legal challenge. Case not initially arrested. However, based on officers' report about intoxication in firearms, Montana authorities initiated red flag proceedings, resulting in temporary firearm confiscation. Case challenged warrantless entry as violating Fourth Amendment. Argued police lacked sufficient justification under emergency aid exception, and everything observed inside, including firearms, should be suppressed. Supreme Court's holding, January 14, 2026. Justice Kagan delivered unanimous 9-0 opinion, holding police entry constitutional. Officers had objectively reasonable basis to believe someone inside seriously injured, based on totality. Neighbors 911 call, officers hearing distressed sounds, repeated unanswered knocks, unlocked door suggesting occupant unable to respond. Number 2. What objectively reasonable basis means. Not probable cause. Court explicitly held police do not need probable cause to invoke emergency aid exception. Probable cause is traditional standard, more than 50% likelihood. Emergency aid exception exists for situations where a waiting to establish probable cause could cost lives, not reasonable suspicion. Court also declined to lower standard to reasonable suspicion, standard for Terry stops. Reasonable suspicion lower than probable cause, but court held too low for home entries even during emergencies, because home is most protected space under Fourth Amendment. Middle ground. Court established new test. Police need objectively reasonable basis for believing occupant seriously injured or imminently threatened with such injury. Evaluated from perspective of reasonable officer at scene, not with hindsight. Must be objective. Officer's subjective good faith insufficient. Must concern serious injury or imminent threat. Minor injuries don't justify entry. Factors courts consider. Nature and source of information. 911 call versus anonymous tip. Officer's own observations. Sounds, smells, visible conditions. Time-sensitive nature of emergency. Attempts to contact occupants. Reasonable alternatives available. Why this matters. For gun owners, objectively reasonable basis is lower threshold than probable cause, meaning police can more easily justify warrantless entries. Once inside, anything in plain view can be observed and reported, including firearms, ammunition, gun safes. Observations can trigger red flag petitions, even if initial entry unrelated. Number 3. Why court unanimously chose this middle ground. Life-saving necessity. Justice Kagan emphasized emergency aid exception exists to save lives. Requiring probable cause would mean officers must wait, gather evidence, potentially seek warrant while someone dying. As Kagan wrote, when someone needs immediate medical help, Constitution does not require officers to stand outside counting to see if screaming stops. Protection of home privacy. Court also emphasized Fourth Amendment protects home as most sacred space. Can't allow police to enter homes freely based on mere hunches. Need meaningful standard to prevent abuse. Hence, objectively reasonable basis. Lower than probable cause, but requiring specific facts showing serious injury or imminent threat. Objective, not subjective. Court stressed test must be objective to prevent officers manufacturing justifications after the fact. Officers' subjective good faith not enough. Must be facts that reasonable officer would interpret as indicating serious injury. Prevents pretextual entries. Serious injury requirement. Court limited exception to serious injury or imminent threat. Not minor injuries. Not general welfare concerns. Not speculative risks. Prevents officers from entering based on vague concerns about well-being. 9-0 significance. Unanimous vote shows court's consensus. This middle ground appropriately balances life-saving necessity against Fourth Amendment privacy. Even justices typically skeptical of police powers, Sotomayor, and justices typically supportive of law enforcement, Alito, agreed. Number 4. How this affects gun owners during wellness checks. Wellness checks increasing. Police wellness checks increased dramatically in recent years, often initiated by estranged family, concerned neighbors, employers, anonymous tips. Under Case v. Montana, police can enter if they have objectively reasonable basis to believe you're seriously injured, even if real motive is to see if you have guns. Plain view doctrine. Once police lawfully enter under emergency aid exception, anything in plain view can be observed and reported. If officers see firearms, ammunition, multiple guns, tactical gear, they can include in reports. Reports often become basis for red flag petitions. Red flag connection. Case v. Montana creates pathway. Concerned party calls for wellness check, claiming person in danger. Police enter under emergency aid exception. Officers observe firearms. Police or family file red flag petition citing observations and original concerns. Guns get confiscated. What police can't do. Police entering under emergency aid exception cannot conduct searches beyond what's necessary to address emergency. Can't open closed containers. Can't search drawers or safes. Can't seize firearms unless evidence of crime or immediate threat. But if guns visible, police can observe and report. Your rights. You have right to refuse entry if officers don't have warrant and you don't consent. However, if articulate objectively reasonable basis for believing someone inside seriously injured, they can enter without consent under emergency aid exception. Refusing entry at that point becomes criminal obstruction in some states. Best practices. If police arrive claiming wellness check, answer door and step outside. Demonstrate you're fine, visibly healthy, coherent, not in distress. Do not invite officers inside or consent. If officers claim emergency for entry, document their stated reasons. Do not physically resist. Document and challenge legally. Do not answer questions about firearms without attorney. Number 5. What to do when police claim emergency entry. Do answer door. Refusing to answer gives police additional basis to believe emergency exists. Answer promptly, step outside, demonstrate you're fine. Do communicate clearly. If officers express concern based on neighbor reports, explain situation clearly. I'm fine. Just dropped something earlier. Or, had friends over, got loud, but everyone's fine. Clear communication can eliminate objectively reasonable basis. Do ask for warrant. Politely ask, do you have warrant? Forces officers to articulate basis for warrantless entry. If they claim emergency aid exception, ask, what specific facts lead you to believe someone's seriously injured? Makes them state on record justification. Don't invite officers inside. Never consent. Sure, come in and see. Once you consent, anything they observe is admissible. Emergency aid exception becomes irrelevant if consented. Don't physically resist. If officers enter despite refusal, do not physically block or resist. That's separate crime, resisting arrest, obstruction. Step aside. State clearly, I do not consent to this entry. Document everything. Don't answer questions about firearms. If officers observe guns and start asking questions, how many guns? Are they yours? Where do you keep them? Respond, I'm not answering questions without attorney. Fifth Amendment protects against self-incrimination. Do document. Use phone to record if legal in your state. Take notes immediately after documenting what officers said to justify entry, what they did inside, what they observed. Crucial for challenging entry or defending against red flag petitions. Do consult attorney immediately. If police entered under emergency aid exception and observed firearms or made reports, consult firearms attorney immediately. Attorney can review whether entry legally justified under Case v. Montana and challenge subsequent red flag proceedings. Bottom line, January 14, 2026, Supreme Court decided Case v. Montana 9-0, establishing objectively reasonable basis standard for emergency aid exception to Fourth Amendment warrant requirement. Standard. Police need objectively reasonable basis to believe occupant seriously injured or threatened. Not full probable cause, not mere reasonable suspicion. Middle ground evaluated from reasonable officer's perspective based on totality of circumstances. Case facts. Neighbors 911 call about crashing sounds and yelling. Officers arrived, knocked repeatedly, no answer. Heard distressed sounds inside. Tried unlock door, entered, and found case injured from fall, plus firearms throughout home. Entry upheld under emergency aid exception. Unanimous. All 9 justices agreed. Justice Kagan authored. Balanced life-saving necessity against Fourth Amendment privacy. Objective, not subjective standard. Serious injury requirement prevents pretextual entries. Gun owner implications. Wellness checks increasing. Police entering under emergency aid exception can observe firearms in plain view. Observations often become basis for red flag petitions. Connection between wellness check and gun confiscation. What to do? Answer door. Step outside. Demonstrate your fine. Do not consent to entry. Do not physically resist if officers enter claiming emergency. Document everything. Do not answer questions about firearms without attorney. Consult firearms attorney if officers entered and observed guns. Subscribe, because emergency aid exception cases developing, and I'm tracking every Supreme Court decision affecting gun owners' Fourth Amendment rights.